Start. Leave granted, full stop, para. Arising out of a dispute pertaining to the execution of the alleged last will and testament of one Thankam, this appeal challenges the final judgment and order dated 30th November 2022 in RFA number 298 of 2019 passed by the High Court of Kerala at Ernakulam, that had in turn be preferred against the judgment and decree dated 18th February 2019 in OS number 156 of 2015 delivered by the Principal Sub-Court, Thrissur, full stop, para. The facts are that the Thankam was the mother of the plaintiff and defendant numbers 1, 2, 4 and 5 before the civil court, full stop. She died on 27th August 2011, full stop. The civil court records that as per the defendant respondents herein, Thankam had executed a registered will as number 35 of SRO, Ullukara, dated 22nd March 1999 and bequeathed her property to the above mentioned defendant numbers 1, 2, 4 and 5, full stop. The plaintiff appellant herein had no knowledge of this will and hence, upon her mother's death, had filed a suit for partition, full stop. It was held that the will could not be proved in accordance with Section 63 of the Indian Succession Act 1925, full stop. A preliminary decree was passed directing the suit property to be divided into 10 shares and the plaintiff appellant being entitled to a 2/10th share, full stop, para. The defendants approached the High Court, full stop, in a judgment of only 2 paragraphs and 3.5 pages, of which more than 1 page is spent on extracting the reasoning of the civil court, the judgment of the court below has been set aside, full stop. That apart, the judgment of the civil court has been termed to be entirely lacking in as much as the court was unable to understand the controversy in issue and the judge has been directed to be sent for training, full stop, para. The dispute involved in pertaining to the due execution of a registered will, Exhibit B1, for which one among the propounders gave oral evidence as DW1 and one of the attesting witnesses was examined as DW2, full stop. During the cross-examination, nothing was brought out to discredit either the propounder or the attesting witness, full stop. The testator was also introduced before the sub-registrar for the purpose of its registration by 2 witnesses and one among the witness is none else, DW2, full stop. In fact, no challenge was raised with respect to the competency of the testator, full stop. She died in a motor vehicle accident on 27/8/2011 and the will was executed 12 years prior to the above said alleged accident, full stop. But the trial court, on some extraneous consideration, found that there is failure to prove the due execution of the will and hence granted a decree for partition, full stop. The relevant portion of the impugned judgment in paragraphs 7 to 22 are extracted below for reference, para. The one attesting witness examined in his evidence has to satisfy the attestation of a will by him and the other attesting witness in order to prove there was due execution of will, full stop. To put in other words, if one attesting witness can prove execution of the will in terms of clause in C of Section 63 of Indian Succession Act, viz., attestation by two attesting witnesses in the manner contemplated therein, the examination of other attesting witness can be dispensed with, full stop. The one attesting witness examined, in his evidence has to satisfy the attestation of a will by him and the other attesting witness in order to prove there was due execution of the will, full stop, para. In the evidence of DW2, it is lacking that execution of the will by Thankam was witnessed by him and the other attesting witness, full stop. Therefore, it cannot be found that the defendants proved execution of the will by Thankam, full stop, para. In the cross-examination, DW3 stated unequivocally that Thankam was illiterate and she could not write or read, full stop. A document can said to be duly executed only when it is shown that the executant signed the document of his own violation after fully knowing the content of the document and at the time of execution he was capable of forming a rational judgment as to its effect, full stop. In the instant case, there is no evidence that the content of the will was read over to Thankam before she affixed her signature, full stop.